There it is. It's got to be green. Hello, everyone. I'm Steve Davidson from Steptoe. Happy to host, happy to be here, and thanks so much for coming. We've got a interesting panel that Will's going to shepherd us through. We've got some great people here, and then we have lunch afterwards, so stick around.
Thank you. Thank you, Steve. For those of you that, well, I'm one of the co-founders of WOW, and my job here is to again welcome everyone. Those of you that have just gotten here, those of you that have just are just attending this session. This is our fourth day of Washington Arbitration Week. It's our fourth session of the day, and we have a wonderful panel. I would like to introduce Will, Marra, and I have a great deal of respect for Will. He has been in the third-party industry for a while, but before that, he has done incredible things. Not only a Harvard graduate, but also a clerk at the Supreme Court in the U.S. And what strikes me, has always stricken me about Will, is that he has an incredibly curious mind from a legal perspective. And of course, there's also a business mind behind it, but from a legal perspective, as he got into funding. I got to meet him before that, and not only a gentleman, but also very curious. If you look into his presentations or the panels that he has moderated, whether at Washington Arbitration Week or other panels, there's always a creative side to it. So I think that, and he knows the industry. So this panel was basically put together because we have to take some stock of the latest developments in third-party funding for perhaps the last I would say 3-4 years, or even more, 8 years. Many arbitral institutions from Singapore, Hong Kong, in Asia to ICSID, ICC, have amended their rules of arbitration and included provisions that to some extent require higher or lower levels of disclosure, and also have to some extent increased the risk for funders with greater transparency, etc. This is still an industry that I believe is one where many misconceptions take place. One of them I heard a few days ago was that the funders really push for there not being a settlement. That's a misconception, because funders actually love settlements to the extent that as an early settlement may lead to some returns at an earlier time. So this is an industry where, even though people know more about funding, there needs to be a lot of demystification. So in this session was put together in order to learn how has the industry developed after some of those rules have been issued, and how is it viable still in international commercial arbitration? Is it viable in investment arbitration? You have an incredible set of panelists from the funding industry. You also have panelists who are counsel and who know about funding. So with that, I would like to turn to Will and take it away.
Great. Thank you, Jose Antonio. And thank you to you, to Maria, for everybody who helped organize the conference, and to Steptoe for hosting us today. I'll do some quick introductions, 2 very short preliminary notes, and then we'll jump right in. So we have Gabe Bluestone from Omni Bridgeway. He's an investment manager and legal counsel there. responsible for the company's judgment enforcement initiatives. Prior to joining Omni, he was a shareholder and litigator at Bluestone PC, a leading asset recovery law firm with offices in Washington, D.C. and New York. And he received his JD from Rutgers and his BA in history from Connecticut College. And after graduating from law school, he clerked at the U.S. Senate Committee on the Judiciary. Next, we have Claudia Linares, the Director of International Arbitration and Litigation at Parabellum Capital, where she is responsible for the development of Parabellum's investments in international arbitration and litigation. Prior to joining Parabellum, she was a vice president at Tenor Capital Management, where she worked on international arbitration matters there as well. She previously practiced at Fowler Rodriguez LLP, worked for the government of Colombia, received her LLM from Colombia with the U, JD from Colombia, Universidad Javeriana in Colombia, Universidad del País Vasco, how was that? In Spain. And so we're excited to have her here today. Next, we have Stephen Davidson, who is Chambers Band 1 ranked in international enforcement. He is our only lawyer or practicing lawyer on the panel today. Described by his clients as a real international statesman, he handles high-profile arbitrations and complex business litigation. He also serves as an arbitrator in ICC cases. He received his JD from Northwestern, his MA from BU, and his BA from BU. And as a Yankees fan, very sad about what happened last night, I will read a quote about his practice. In connection with his work on behalf of ExxonMobil against Venezuela, it was written about him, was it in the Wall Street Journal?
It's the Stephen Cole's book on Exxon.
Oh, right, Stephen Cole's book. Quote, for the Steptoe attorneys, the late December Friday afternoon seizure of $300 million belonging to Hugo Chavez's government was like hitting a walk-off home run in the bottom of the ninth before a full house at Yankee Stadium. So high praise for your practice. And finally, we have Jeff Commission, who's a director at Burford Capital with responsibility for assessing and underwriting legal risk as part of Burford's investment team, focusing on investor state and international commercial arbitration. Chambers has said about Jeffery, they have a brilliant team for international arbitration matters, particularly Jeffery Commission. They are the most knowledgeable and most sophisticated in the business, and he is the author of the treatise Procedural Issues in International Investment Arbitration. Now, just two quick preliminary matters. First, by a show of hands, who here, first of all, has used litigation funding for any of their matters? Who here has been involved in litigation where they suspect there was funding on the other side? Okay, so that's probably about 2/3 maybe of the room has been involved. We've got a number of topics that we're going to discuss, and in between, we're going to have 2 lightning rounds of questions, which will be very short, quick hit questions. There'll be 4 each round, and I haven't told the panelists this, but only one of you gets to respond to each question. So the last person to respond has to respond to the last of the 4 questions. So we'll jump right in. And we'll start just with setting the stage, talking about the uses of litigation funding, how it's being used today. And maybe Claudia, you can kick us off here. Tell us a little bit about how parties are using litigation funding today in international arbitration. There's a lot of different stages of a case that funding might be used. There's also different types of cases, commercial arbitrations, treaty arbitrations. Give us an overview, if you can, of where funding is being deployed in international arbitration.
Sure.
Except hit that little button on the top before it goes green. There you go.
Works?
Yeah.
Yes. So, well, thank you so much for inviting me and to Steptoe for hosting. This is my first Washington Arbitration Week, so I'm excited. Hopefully not the last one. So parties are using litigation finance in all stages. We get many cases that are not yet filed, so in very early stages. But we also see cases that are running, so advanced. And and maybe one of the parties or the claimant thinks that they need money, and then they come to a litigation funder to get the case funded. Additionally, we can also, do funding for annulment and for enforcement, and also award monetization. But when it comes to award monetization, I find it's very difficult for claimants to digest the fact that after long and complicated arbitration proceedings, they, have to sell their award at a discount, unless we are speaking about a country against which enforcement is very difficult. Imagine Venezuela. So for this type of situations, I find that it's easier to fund enforcement rather than, do monetization. And, if you structure the economic terms of the funding to make, all parties align to share recoveries until the last dollar, it's a formula that I think is effective. So basically, we are funding both commercial arbitration and investor treaty cases. I think not all funders are funding investor treaty cases, and probably that's a topic that we'll discuss later on why they are not doing it. But we are. Also, I wanted to clarify that the name of our fund is Parabellum Capital and not Capital, as it says there. I think it's important to clarify that.
Stephen, anything to add to that? What are you seeing as a practitioner in this space?
I think to follow up on what Claudia said and to reinforce, there's a lot of use of funding. I think, I've been in the kind of arbitration world and particularly the judgment enforcement and execution world for a long time. So for 20 years ago, 25 years ago, there really wasn't much of it. And in the last decade or even less, it's really become very prevalent. And especially as Claudia said, in the enforcement area. I mean, there's an area where, oftentimes the finish line is easier to see and there are fewer hurdles along the way. So I think, the trend I've seen has been more use of it in enforcement area. And as Claudia said, and we'll all touch on it different ways, a little bit of disfavoring in investment treaty due to the length and uncertainty. And then because a lot of the cases are against sovereigns that are difficult to collect against or in real financial distress, the question of putting money into one of those is, become more of a very open question.
So, Jeffrey, I'll bring you into this. And there's an interesting definitional question. We think about litigation funding. It is providing capital to help someone to pursue litigation. And there's third-party litigation funding, which adds a little bit of something, which is that you are someone who is not yourself the claimant, which may or may not be the case depending on how the investment is structured. Are you acquiring the claim, thus in a sense becoming first party? Are you financing it as a third party, not actually a party to the litigation? Can you tell us, Jeffrey, about what you're seeing in terms of how these transactions are actually getting structured? And is it accurate still to use this shorthand of third-party litigation funding, or as the asset class becomes more sophisticated, are we seeing different and more sophisticated transaction structures?
I've never liked third-party litigation funding as a term. Quite frankly, I'm surprised it's lingered and stuck this long. I think when it was used in the task force report, I think we were stuck with it. I much prefer arbitration finance because arbitration finance is a better descriptor for what I do these days. We are many years away from the single case financing. We are in a world now where I spend half my time funding cases, on a single case basis or in a portfolio, providing working capital for companies that have claims, but importantly, monetizing awards. It's about half of what I do. And is this new? Is there a greater trend towards the monetization of claims or awards? I'm not sure there is. I would make 2 points. First is I think there's more transparency about these transactions now. It's not new that ICSID awards or UNCITRAL awards are being monetized. The awards against Argentina, the CMS award, the Continental Casualty Award, the National Grid Award, those were all acquired. by funds. And then the years that followed, awards against Venezuela, like the award that owns Illinois, well-known American institution, they sold that award to a fund that's domiciled in Ireland. And then thereafter, you did a couple more Venezuelan awards. The Linares and Talto awards were sold to a fund based in New York. So it's quite common. What historically wasn't common was that people didn't know about these transactions. Now, people are learning about them through Pacer, because a lot of the deals, or at least certain descriptions of the deals, are available publicly. And companies themselves, when they receive awards, are explaining to their investors that they are looking at a number of things to do with that award. One is enforcement. One is assessing whether or not that award is going to be set aside. But thirdly, they're exploring the possibility of monetization. You saw that when Cairn Energy, for instance, who ended up settling with India, but they announced to their investors that they had a large award in excess of $1 billion. They publicly announced to investors that one of their strategies was to potentially monetize an award. So that didn't happen 10 years ago. So we have come mainstream. And the second point I would say is the players are different, in that, when we're funding a case, we compete against certain funders. When we're buying awards, we don't really compete against that many funders these days. It's really multi-strategy firms. So, hedge funds, basically, for which this is just another distressed, as you put it, Will, asset class. And I think that's where we are today.
Gabe, can you weigh in here and maybe you focus a lot on judgment enforcement. What do those transactions tend to look like? And at the time that folks are coming to you, how have they prosecuted that case, right? If they don't have the capital, maybe they just don't have the risk tolerance to go enforce the judgment, so that they're coming to you. What has that case looked like to the point where they actually get the award and now you're coming in to enforce the judgment?
I think it's probably a combination of self-funding and some risk by the lawyers. But I think it leads to an interesting sort of middle ground between your traditional third-party funder coming in at day one and what Jeff's talking about, a monetization post-award. I think there's a lot of monetization opportunities for a client who spent $3, $5, $10 million to get a large award, for a funder to come in, give some amount at close, and fund an enforcement campaign. So what I think as the industry matures is that you have a spectrum of opportunities for claimants, for law firms, for everyone on the spectrum to sort of pick from the menu of options that may suit their needs. Is it liquidity today versus, waiting 3, 5, 7 years for a resolution? Or is it, some smaller amount, maybe 50% of the enforcement budget to be covered by a funder? So, and just going back, Will, to your original sort of polling of the audience, can I ask who would like to work with a funder or anticipates that clients of theirs have interest in funding, or if it's something folks are seeing more of? It's 3 questions, but are there folks who who anticipate clients needing or seeking funding going forward? One, few, okay.
So in my own work as a funder, we have our third-party funding cases where we do maybe bi-weekly or monthly check-in calls, very hands-off. And then we have our acquisitions where it's more appropriate for us to be more actively involved, at least through a manager that, for example, that we've appointed. And I guess this is a question for anyone, the funders, but maybe also Stephen, if folks in the audience are thinking, hey, I've never worked with a funder before, I'm trying to understand what that engagement is going to look like. What are funders doing on a day-to-day basis? Are they just writing checks? Are they managing the litigation? Maybe they are if they've acquired. What does that kind of monitoring process and engagement process look like over the life of the investment? If anybody wants to handle that one.
I mean, from the lawyer's perspective, the typical has been sort of, and every one's a little different, but they have kind of a format for reporting. And, typically kind of a monthly report that they either have a certain form they want you to follow or tell you what information they want in it. And you do that regularly along with, sending the bills and how that compares against the budget. and, have periodic check-in. I mean, the funders are the same as clients in the sense that the better relationships you have with them are caused by having more communication, more openness. And when something important happens, let them know. And I've always found, I'm not just saying this because you guys are here, but I've always found funders to be pretty good on that side of it, not being, most of the people we deal with, like you guys, are lawyers. So, and many have had expertise in this area before becoming full-time funders. So they add value and have been around the block a lot. And I found it to be a good relationship. I mean, the only sources of tension, not surprisingly, the main source of tension is like budgetary issues. If you're going over, or it's too much, or it's going to have to explain why it's going over. But, if the case is going along reasonably well and you're sticking to the budget, I found it to be a very collegial and helpful relationship because people have value to add.
So now let's talk a little bit about the demand side for funding and then the supply side, and that'll bring us to a conversation about what are the risk factors and the criteria funders look for when they're thinking about funding a case. So to start first on the demand side, who is seeking funding today? The way that I've thought about it is you have folks that are distressed, so they just don't have the capital. But you also have some very sophisticated users of litigation funding that maybe have billions of dollars in the bank, but find that this particular corner of the capital market is a more efficient way to raise the capital they need. Maybe Stephen, if we can go back to you, if you want to start us off here, what are you seeing in terms of the demand side for funding? Who seeks funding, and are these claimants that have known about the asset class for a number of years and it's a long process to get there? Or is it something, for example, that you or maybe a funder is introducing them to?
Well, I think, at least from my experience, most of the use of funders in my cases have been by clients who don't have the capacity to fully fund the case. There are some, as you suggested, Will, who decide they want to deploy their capital elsewhere, have it partially funded or fully funded, give up some of the upside in exchange for less risk and the ability to use their capital for something else. But, one of the biggest trends, I think, in the last 20, 30 years in the legal world has been moving away from total by the hour relationships with clients. So when I started practicing law, that was really all there was. That plus like pure contingencies which were mainly, kind of your traditional products, plaintiff's injury kind of cases. Commercial disputes really didn't have that. So, and then clients started wanting alternative fees in which, they have caps or they have some kind of incentives and so on. And I don't know whether that naturally evolved or whether it developed separately, but the litigation funding industry as sort of an engine of, I think, Anglo-American capitalism kind of really got going as a way to fill a void. I don't know if it creates more demand in the sense that it creates more litigation than would otherwise be. I'm sure there are some cases that go forward that probably wouldn't if it weren't for funding. But I think it's mainly people who want to bring their cases probably would try somehow to find a way. Maybe if there weren't funding, they'd go to a contingent fee case, firm, and that would probably put them in a less advantageous point of view. They'd have to give up 20, 30, even 40% of the upside for a pure contingency. So, I think the demand side is high. And clients know that it's an available resource. So I think it's driving it. A lot of the money, I think, in funding has been spent in treaty arbitrations and in big judgment enforcement cases. And it's prevalent to some degree in more traditional commercial cases of two commercial parties. But I think there's more room for it there. And it'll be interesting to see if more of it goes into that area, particularly as we've all sort of intimated that the desire to fund investment treaty cases may be waning.
And Claudia, maybe we can turn to you to talk a little bit about Maybe we can talk to you to talk a little bit about the supply side. So you have here three of probably, if not the top 5 to 10 arbitration litigation funders in the country, right? You don't just need capital to do this, you need expertise. And even if you have a lot of capital that wants to enter into the space, there's not that much expertise out there. So we mentioned a little bit earlier the commercial versus treaty arbitration divide, but realistically, how many funders are there out there that have a significant appetite for these kinds of cases?
For investor treaty cases?
And commercial, yeah.
So, Parabellum traditionally has been a US funder. So the bulk of what we do is US litigation. But they started seeing international cases. So they hired me almost 4 years ago to basically run that vertical. And while there is appetite, the main concern of our investors is usually how long these cases take, especially investor treaty cases, as we all know. However, there is interest in this type of cases because of the size of the damages and the potential returns. And also, to have a more diverse portfolio of investments, not only, let's say, in the US, but also to have different type of risk. So for us, there's still a lot of interest in international investments, especially, commercial cases and investor treaty cases. Only a handful of funders are doing investor treaty cases for the reasons we mentioned. We do a lot of portfolios. So while we do single case investments, we do portfolios because it's a way for law firms to, build or attract business by having a relationship with a funder and setting up some sort of a facility in which you add 2, 3, 5 cases and returns are cross-collateralized amongst the cases. And then it's a great tool for lawyers to go and develop business because they can actually get clients that, sometimes they are uncertain if they are going to pay for their fees. And especially in international arbitration, I see this truly helps, let's say, for example, women, and I see a lot of women in this audience, to develop a book of business. If you have a funder and a good relationship behind, and you can go and find, let's say, for example, I'm Colombian, so find business in Latin America, where, for example, international arbitration cases tend to be on the smaller side of damages. So I think it's a great tool for lawyers, and I think there's still appetite. But obviously, if the system continues to be as low as it is, I think funders are going to have second thoughts about it.
And this is it's a great point, and it's an important point of clarification here, which is a funding agreement can be structured between the funder and the claimant, and it can be structured between the funder and the law firm. And particularly when it's facing the law firm, it can be funding a portfolio or a basket of cases, which can help as the funder evaluates their risk profile. And let's turn to that now. And Gabe, maybe you can lead us off here. Tell us a little bit about the risk factors that a funder thinks about when they're deciding whether to fund a case. And I'm in particular interested in, are there any new or emerging risks that you're seeing today that maybe didn't exist 2 years ago, for example?
Yeah. I think I'd first break it into 2 buckets. You've got your quantifiable objective elements of a claim. The legal merits, are they strong? The damages, the quantum, are they adequate enough to sustain a budget and an investment that's being requested? And third, the third leg of the stool is your enforcement payment capacity analysis. Doesn't do claimants and especially funders any good to have a award or a piece of paper that can't be satisfied. You then drop to the subjective elements. Who's the legal team? Is this a jockey that, as an investor, we feel comfortable can shepherd a case from, initiation through award, through annulment and enforcement successfully? And then the important thing that the investors, the funders are looking at is the economic structure. Are the lawyers on some element of risk? Are we all rowing in the same direction? A big piece of this is, we're all former, Steve's still practicing, but the funders were never as close to a matter as counsel is. And the way we often sort of prevent against knowing things we're not going to find out, we're not able to look at every email, is when lawyers or counsel are willing to take risk and meaningful risk oftentimes. That's something that our investment committee likes to see. That hedges against this fact that funders can't get to everything that the lawyers can. So those are sort of the main high-level objective and subjective factors. When I think of new risks or sort of more recent risks, I think in the investor treaty world, it's the obvious geopolitical concerns that we all read in the newspaper every day. We of course hire outside experts and do enhanced diligence, but oftentimes, we're paying a lot of money for something that most of us can glean from reading the newspaper or talking to friends in the know. And I think the obvious point, which Claudia mentioned, is the growing duration risks. As investors, Omni, Bridgeway, we're publicly traded in Australia. We've got our LPs. We have hurdle rates that we need to hit. And anyone who's ever looked at how IRRs work and how they get strained over time will build an appreciation for how funders have to look at these things. When you stress test an economic model and you add 2 years and you add time to that, and you add annulment and you add enforcement risk, these investments take a long time. So there are criticisms that the litigation funders, capital is expensive, but I would just suggest that you spend some time playing with an IRR model to see what it looks like when you put money out on day one and have to wait 5, 7, 10 years for a resolution, especially in the investor treaty enforcing against sovereigns.
For our own pipeline at Certum, to give folks some context, we probably invest in maybe 3 or 4% of the opportunities that we see every year. That doesn't mean that only 3 or 4% are strong enough on the merits. Maybe 20% of them or 25% or maybe more are strong enough on the merits, but you have all of these other factors that come in. And then of course you have to win the deal, right? Because, Jeff and Claudia and Gabe are trying to get the deal too. And Jeff, maybe if you have anything to add to this, what does your pipeline look like? What are the stages you're going through to get a case from intake to funded?
I think, first of all, I think it's important to note that I wouldn't advise any funder to just fund international arbitrations, full stop. I don't think that fund would succeed. I think you need to have a balanced portfolio that includes more than international arbitration. Because as you've heard today, these international arbitrations take forever to get from filing to collection of award proceeds. So if you were banking on just arbitrations and you don't have a mix of ICC or LCIA commercial arbitrations that are going to turn around in 2 years, 2.5 years, you're going to be waiting a long time for that capital to come in. So, I mean, for us, our portfolio is over $7 billion, about 15 to 18% of that is arbitration. So at any given time, we're funding dozens of arbitrations around the world. And obviously we don't manage them, we monitor them, which is important. But I think in terms of risks, one would be the concentration risk, I think. We see that in respect of certain sovereigns. And that could be that, in the last year, we've seen a certain Latin American sovereign that's faced a multitude of cases. You have to be cognizant of the capacity of that sovereign to be able to pay an award if you're successful in 3 to 5 years' time. Other sovereigns have a lot of awards against them and they, for some reason, are not paying them. So that's also an issue. And that factors into pricing, both in the secondary market and initially. So I think, and then you've got issues that you wouldn't have anticipated necessarily, like issues of sanctions. So you have an award, you get a settlement, and now you've got to get OFAC, or you have to get an OFAC license. That wasn't something that when you signed up to do the deal, you had envisaged, for instance. So I think that's an added element. And that, I'll end on this, is I think everyone will ask, clients will ask, how long will this arbitration take? And you can say, well, the average exit case is about 3.86 years. And then, they say, if there's annulment, then it's another 18 months to 24 months. What we heard earlier this week from Martina is, half of the cases, she was giving stats on ICSID's year. Half of the awards that were rendered are now the subject of post-award proceedings. So annulment is particularly active. There's a number of annulment applications. And if you were to cross-reference the number of annulment applications with the number of funded cases or cases where the damages claimed are over 100 million, it's just about all of them. So you almost have to factor in, and we do it now in our budgeting, an annulment proceeding for many of these high-value cases, because states are using them even if it's just an opportunity to delay payment. So I'll stop there.
And I'll ask one more question on this topic, mindful of the time for Stephen, which is, as I think about arbitrations, the two biggest risks are duration and collection. Those are sort of omnipresent and ever-present risks. Maybe one way to think about the question is, are they getting better or are they getting worse? Those risks. How have you seen that change over the past 5 years or so? And question, does funding have anything to do with them getting better or worse?
Well, the collection risk, I mean, I have somewhat of a maybe jaundiced view, because a lot of my work is when people bring awards to me to collect, where someone's refusing to pay. So I'm sort of like, does anyone actually pay without having to go to court? I'm still, I see those so rarely in my world. So my world may be different than the world at large, but I think commercial parties are more willing, if they lose, to, if there's any kind of prospect of setting it aside that's real, they may take that. But, for them, just sort of playing out the string on a hopeless challenge under the New York Convention isn't really worthwhile. They run the risk, even if fees hadn't been awarded, of fees being awarded, some kind of punitive interest rate. The sovereign cases, though, that's really not the case. I mean, Jeffery alluded to it about sort of a delay tactic. And, a lot of sovereigns, even ones that you don't think of being sort of rogue nations, are now embroiled in a lot of litigation and are refusing to pay. I mean, you see Spain and other European countries that, and they may feel they feel they're in the right, perhaps, and it's not just delay, because they feel like they shouldn't have to pay these awards, but they go to great lengths to follow every kind of opportunity they can not to pay. And with sovereign, and then to me, there's sort of two other classes. There's sort of the essentially bankrupt countries, the Venezuelas. And then there are some in between that have the money to pay, but through internal bureaucracy or changing of governments, or no one wanting to be the one who's responsible for having paid, they kind of let these things go out. So I think enforcement has gotten more difficult and longer. I don't know. It's an interesting question, and I don't know the answer, but I think what you just asked is, has funding contributed to it? Do people think that that the other side will go out longer, or that it's not their own money at risk? So maybe it's an interesting question about whether funding creates disincentives to pay judgments from the respondent side.
And I just generally, I think this is an incredibly interesting topic, third-party funding, and there's probably like 40 topics that we wanted to cover that are on the cutting room floor, but we are going to do our first lightning round, which is 4 quick questions, and everybody just answer one of the questions. First, what is the single biggest underpriced risk in international arbitration today?
Is it like Jeopardy?
Someone just jump in. Yeah.
I'll say we said duration, and I think that's the obvious one, but I really think it's payment capacity. I think there are a lot of folks who assume payment capacity, lawyers who are accustomed to not being on any risk and not necessarily thinking through these issues. So I'll say payment capacity.
Secondary markets, it is important to at least mention the topic. Primary market is a funder first doing the investment themselves. Secondary market, them then trying to resell it to another funder. Are we moving towards, or is there today, a bona fide secondary market for arbitrations and awards?
I'll answer that, and the answer is yes. It's here now. It's happening. Yeah.
How prevalent?
I mean, on this, I mean, the award monetizations to which I alluded before, many of those are in the public domain. The syndication or the secondary market transactions happen with some regularity, but they're not in the public domain. But yes, I mean, I think this happens. I mean, we did one some time ago, and you know, there's a number of firms that are active in the space. So I think we're here now. I don't know. There's no particular reason why these transactions would become in the public domain, but you know, I would say we're here now. What we haven't seen yet is the bundling of various claims or awards into different units. We haven't seen that yet, but I could see that happening in the future.
What's the most common misconception folks might have about the enforcement of arbitral awards?
That people pay.
Yeah, and kind of in tandem with what Jeff's saying, sort of the bid-ask spread between what claimants think an award is worth and what funders and investors think they're worth can often be too wide a gulf that can, you know, doesn't lead to enough deals. So maybe the secondary market becomes more mature and there is a, you know, a better way to do it, but I think we run into challenges on those differing views.
And if we look in our crystal ball 5 years from now, what will surprise us most about the funding industry in arbitration?
So just last week, I read that AAA and ICDR are launching an AI native arbitrator. So this is like in the very near future, November 2025. And basically this tool will replace arbitrators. They said that it's for construction cases only, and it's based on information, you know, the bulk of the information they have on this type of cases that are, you know, document heavy, and what they say is that they need to be very fast, resolved very fast, etc. But you know, this blew my mind. I was expecting this, but not so fast. And while I don't know enough of this tool to comment at this point, I am not sure how the funding industry would react to that. I have very mixed feelings because I have been working in this industry for 8 years, assessing risk, but based on human thinking and what I know of the law and what lawyers tell me the law should, you know, the law should look like. So this is like very new, but it's coming. So
Interesting.
My crystal ball is very gray at this point.
I like that.
I'd add too, will funding go to the sort of respondent defendant side more?
Yeah. So 2 more large topics that we want to cover in the 25 minutes we have remaining, and then also we want to leave some time for questions. The first is the impact that funding is having on the litigations themselves. And then second is regulation. So most of us became lawyers because we didn't want to be involved with science, but there's the rule that for every action, there's an equal and opposite reaction. So the presence of funding in a case is going to have some sort of an impact. And so I would like to spend a few minutes on that. How are respondents and how are arbitrators responding to the availability and the presence of funding in their cases? Claudia, maybe we can start with you. Are there any subjects? I know one of the things we talked about is security for costs. Either in that topic or in any other topic, procedural or substantive, are we seeing funding having an impact on the substantive rulings of arbitrators?
So I've seen an uptick in security for cost requests by claimants when cases are funded, and also orders by tribunals when a funder is involved. However, I think, you know, tribunals should still do a case-by-case analysis of whether they should grant this type of orders, and you know, whether the company is in financial distress, so they will not likely pay for a potential cost award, whether there's a prospect of success by the claimant, whether they have failed to pay awards or judgments or arbitration costs during the process, whether this will create or not hardship or undue hardship on the party, and it is fair regarding the circumstances. But I think generally arbitrators whenever they see that there's funding, they feel somewhat comfortable in ordering security for cost.
And Stephen, client will come to you, I'm thinking about using funding. We've talked about the great benefits. Is there anything that you're telling them, hey, you may need to be careful because the presence of funding injects this risk, or this might happen if you get funding rather than pay out of your pocket?
I think when funding first became prevalent, I don't know exactly when that was, but 5-10 years ago, or when it first came on the scene, it was almost it kind of was a little bit of a shock to the arbitral system, in that it was regarded as this sort of extraordinary thing, like, oh my God, there's a funder in the case. What do we do? And there was a lot of sort of almost like an aha moment for a respondent, like that somehow gave them an opportunity to do things like get security for costs or somehow create skepticism to the tribunal about the case, because it's funded, it's not the claimant's act money, so somehow it must be devalued. And I think there was a period where we kind of went through that, and now I think it's stabilized more, that it's sort of a normal part of the world, and that tribunals, arbitrators, institutions are learning how to adapt to it. So there are certain things, like Claudia said, is it more likely to get a request for security to cost? Probably. But that's a pretty common tactic nowadays for respondents, so no one should be terribly shocked by it. But I think it's normalized more, and that it has become less of an issue in cases and impacts the procedure and the decision making far, far less than it did, say, 10 years ago.
And this topic, we're not quite done with it yet, but will help segue to the regulatory topic, because one of the big underlying questions or issues with the disclosure of litigation funding is how will this impact the arbitrator's view of the case? Now, in arbitrations, you are coming, I think, generally towards a consensus that at least the fact of funding and the identity of the funder should be disclosed to the extent that the arbitrator practitioner might have a conflict of interest. Now, on the one hand, one might say that the presence of funding will make them suspicious. On the other hand, they might say, hey, I listened to this great panel at Washington Arbitration Week, and funders fund less than 5% of cases that they see. So actually, that's a sign of the merit of the case. Gabe, talk us through kind of your thinking about this. When you fund a case, when you acquire a judgment, how are you thinking that your presence might impact a decision maker's view of the underlying merits?
So I might be biased. I'm definitely biased, but I think when you know, like we know, what funders do to diligence and evaluate an opportunity, I can only come to the conclusion that panels, arbitrators, judges must think, and I think some of the data bears this out, that it validates claims. I mean, there are opponents to the funding industry who, and this dovetails with the regulatory piece, that say that funders provide capital for, cases that aren't meritorious, and just couldn't be further from the truth. Arbitration litigation is, as everyone in this room knows, is so hard to predict. The fact that, we have significant chances of losing every case, and to fund cases that aren't merit-worthy just isn't how we operate. And the diligence we do in hiring outside counsel, internally vetting, I think is by and large a process that concludes that cases are meritorious and should be, and shouldn't give any doubts to panels or arbitrators making decisions. I'd like to hear more, though, Will, where you think it may create suspicion. Does it flow from the argument that funders just throw money at cases willy-nilly?
It's an interesting question. I mean, it's to a point Stephen made as well, that what you don't know or necessarily understand or have experience with or worked with can be, I don't know if scary is the right word for this, but it can raise concerns, and those may or may not be well-founded, but they might be there. And I think in the US, at least, where I focus most of my work, I think that is animating some of the arguments by funders to resist disclosure. Jeffrey, what do you think, and how do you think about what the presence of funding will do to the merits and the judgment in the case?
I mean, I think, and I used to do this for the long. I mean, we speak about the role of funding and if a case is funded and the impact it has on the tribunal, but it's kind of like asking, does the claimant have counsel? Okay, they're represented, but who is the counsel? What is their experience? What is their expertise? How long have they been at this? What I worry about, what keeps me up at night is the 5% or the 4% of cases we turn down, because increasingly, and we monitor those cases. So, and we're taking advantage of all the data analytics and AI to do that. But we like to see where these cases go. And increasingly, some of them are being funded. So although I think the major players are rigorous in their due diligence and their investment decision-making process, some of these cases nonetheless end up before tribunals. And we're starting to see, with the introduction of Rule 53 by ICSID and Rule 14, some of these decisions. So there's been, just this year, there's been at least 7 of them. And historically, security for cost application had about a 6% success rate. This year, there's been 3 that have been granted, 2 that have been denied. So they're batting better than average. But if you read some of and I brought one because, first of all, I saw the tribunal and I thought, how could that tribunal order security for costs? It's a great tribunal. I would love to be funding a case with this tribunal. But then you read the procedural order and you read the funder or the so-called funder that's involved in it. And in this case, it involves a claimant that's bankrupt, number one. It involves a claimant that had previously filed a case at ICSID that was ultimately dismissed for manifest lack of legal merit. So that's 2 bad strikes. The third strike, there was a cost award that was unpaid that the respondent got. So it's not looking good. And then it turns out it's funded. It's funded by what appears to be a shell company. And this is all in this order. It says, this company is a new company formed to fund international arbitrations that are not usually funded by the big funders, such as claims of bankrupt companies or cases against states that are regarded as risky respondents. And this funder was constituted with about $200,000. And it's all here. And it's just, some cases that get through are funded by these entities that, yes, they're funders, but it's difficult for me to consider them reputable funders because, I looked at this case and I struggled to see how anyone would put $1 behind it. So that does concern me.
Yeah. And we frame this as sort of how do arbitrators react and then how do respondents react. And I think that actually is a segue to the regulatory question, because in many ways, the regulations are sought by folks who tend to be on the other side of the V. We certainly see that in the United States. Claudia, can you tell us about, this is a very big question, so you narrow it however you want, but tell us just at a high level, what's the state of regulation of litigation funding in international arbitration? And maybe one way that you can help us understand it is, are we talking about disclosure issues, or are we talking about disclosure, for example, just the funder, or are we having to disclose more that it could actually undermine the merits? Are there rate caps on what funders can charge, things like that may go a little bit more towards constricting the supply of funding?
So there's a tendency to regulate by institutions administering arbitration claims. For example, fairly recent changes to the ICSID rules, ICC, and many other institutions across the world We are also seeing, for example, the issuance of guidelines by the IBA or the Charter Institute of Arbitrators that issued one recently, which touch on issues related to funded cases. I think mostly this, regulatory changes concern disclosure, security for cost, updating tribunals on whether, funding situation has changed. I think part of it is focused on conflicts and kind of clearing that. But also I think, for example, I'm starting to see some BITs that restrict the use of funding. So for example, I think Argentina signed a BIT or a couple of BITs. I think one is with the UAE that actually excludes the possibility of funded claims. So, those are different ways of regulating arbitration finance, as Jeffrey would call it. And I think, most of these efforts also come from respondents, as someone mentioned before. I don't think we are seeing, I think we're seeing more and more regulation rather than the opposite, which in my opinion is fine as long as regulation is reasonable. So, for example, I disagree with having to present all of the funding documents to a tribunal or the counterparty, because there are many things that are considered. And as we have all discussed, funding international arbitration requires an in-depth analysis of the case and the circumstances, how long it takes. So I think if a tribunal actually sees those documents, it could have an impact on their decision for many reasons. Also because we put a price on the risk. So the risks that Gabe, for example, mentioned, that's, that process of underwriting requires doing an economic analysis of the case, duration, enforcement. And that reasoning is if you show a tribunal the funding documents, it's very hard that they would understand, the reason behind that pricing. Some of it is market. Sometimes we are competing amongst each other. We are friendly competitors, by the way, friends. But at the end of the day, I think that's not really necessary. So, if they want to know, for example, if the funder will pay for an eventual award on costs, maybe you can show that specific language or show it in camera to the arbitrators. But at the end of the day, I don't think, disclosing funding documents is necessary or can help in any way.
Jeffrey, as the person who wrote the book on procedure in international arbitration, how should folks in the audience think about some of these procedural, you could say, regulations and how they impact the case?
I think we're at a place now where most arbitral institutions, but for the LCIA, which considered but did not adopt a rule mandating disclosure of funding, most institutions have a relatively modest disclosure regime. So it provides for the disclosure of the fact and name of the funder at the time of the submission of the request or notice of arbitration, which I don't think is unreasonable. It's a way to avoid any particular conflicts. What I think is different now is we're seeing increasingly in that first submission, claimants are not only flagging to the other side that the fact that they're funded, they're also flagging in their request for relief that they may just seek those third-party funding costs as costs to be reimbursed. And that's something I think we're going to see more of. But I agree that tribunals, although the likelihood of success on a security for cost application when presented with certain facts, it's likely to get higher. Tribunals consistently, though, are taking the right decision on disclosure of funding agreements. There's been a couple this year that have been, although not yet public, there's been reports about them. Tribunals have drawn the line there, which I think is helpful. So I think that the regime as it stands, I think works. The changes were relatively modest, and I don't see any of these institutions, and being involved in some of the rulemaking efforts myself, I don't see them adopting anything more strenuous. What does concern me, though, is something that we'll talk about in a little bit, which is obviously arbitration is something that operates pursuant to the seats, pursuant to the arbitral rules, but it exists in a much broader society. And I think there's other forces against funding that don't target international arbitration, but that have an impact on funders that could, in an ancillary way, impact how arbitrations are funded.
Yeah. And this is a very rich topic. I want to leave time for audience questions, but Stephen and Gabe, first, I want you both to have an opportunity to just weigh in on the regulation question. Where you see the state of the law today and where you'd like it to go.
Well, it's an interesting question because depending on what kind of arbitration it is, the desire for regulation or the desire to suppress funding is very different. In commercial arbitrations, sometimes a party seeking funding is, maybe a U.S. Chamber of Commerce member, or otherwise a party that you would think might be in favor of tort reform, but they see a reason in a commercial dispute between two parties of doing it, and then you see both on the respondents in sovereign arbitration sort of being anti-funding because they review that as a stimulant to funding. So it's interesting in predicting the future, it's a little difficult because the funding world has many different parts of it. Commercial cases, the sovereign cases, and then which Gabe and I have talked about, and I'll hand it off to him, is that in areas of sort of traditional U.S. plaintiff side kind of mass tort, product liability, those kinds of cases. There's more of, and I don't know if you all would consider it litigation funding because a lot of it is investments by hedge funds and not traditional litigation funders, but there's a lot of money going into plaintiff side litigation, which I found, as I've learned about this, surprising because you always thought, well, they've got their 30-40% of the take, but there's so much money being used to fund these things. You probably see the ads on TV for the Roundup or Camp Lejeune or all these other kinds of mass tort cases. A lot of that has got a third party backer behind it. And that has gotten the attention of the American insurance industry and others, and there are various bills that have been going back and forth about increasing the taxation on funders. Some of it seems to have moved more to attacking offshore funders, but Gabe, you and I have talked about this before on kind of what impact that could have on your industry.
Yeah, and I think this is we could spend hours on this issue, but I think it really boils down to two things. There's a lot of nuance into the different types of funding. There's arbitration, there's litigation, there's mass torts, and I think that leads to the second point, which is just really a misunderstanding for the most part by legislators, and ultimately maybe it falls to us in the funding industry. We have a trade group, but I think, it's the funding industry is probably in the second inning. And it's still a small industry in contrast to the equity, debt, other investment markets and asset classes. And I think we've got a lot of educating to do and relationship building with, whether it's trade groups, whether it's the insurance world, whether it's legislators, because I know all of us go to work each day and sort of are proud of the cases we're funding, which by and large, the goal is to make parties pay market rate settlements, which I don't think anyone would really disagree with. And it's just, how do we get there? And, but there are, money, deep pocketed interests who don't want to pay market rate settlements. And, so we'll see where it goes, but it's obviously, for Omni, a global funder dealing with, updates in England, the US, Australia, there's a lot of, and obviously across the 50 states, there's a lot of attention paid to these issues.
There's a lot more we could cover, but I do want to leave some time for questions if we have a couple of minutes.
Hi, thank you for the panel. It was extremely insightful. My question is sort of a three-step question. One is what if there are potential conflicts between the funder or financier and the claimant? How do you deal with those potential conflicts? And who calls the shots in shaping the strategy going forward? And lastly, how are practitioners supposed to approach these conflicts?
So I think, so I always say that a funding relationship is like a marriage, at least like, length depends on, how early you get a settlement or a payment, but you do have to make sure you have a good relationship. That's why we do background checks on the claimant, and also, on the law firms to make sure that we feel comfortable with the relationship. You want to have a positive relationship during the duration of the case. However, that's not always the case, especially in investor treaty cases where you have, sometimes individual claimants whose investments have been totally destroyed. They don't have money and they're, struggling, because that adds, some human and personal drama. So I always try to fly across the world to actually meet my claimants in person and see if, we have good chemistry and we can actually build a strong relationship. And as to, management or monitoring of the case, I think, you have to let the client be the decision maker, and you have to let the lawyers be the lawyers. We are not lawyers for anyone in that, relationship. We are just, a third party that is, one step removed, looks at the documents, looks at pleadings, hears about general case strategy, does, monthly monitoring of the cases. But you have to try and have a good relationship with all of the parties. And how do you solve conflicts? It depends on what you negotiate in your agreements. In another funder that I used to work with, sometimes we would have, a third party or like an independent party that would try to mediate any, conflict between the parties. But it also depends on how involved you are. It's different if you actually purchase a claim, or for example, there's also litigation financed by acquiring a piece or shares of a company. So you would have a more active role if you do that. Normally the litigation is just structured as a non-recourse loan, and we set dispute resolution procedures in the documents, but you never want to end up in litigation with any of the parties involved, because it can become public, obviously, especially here in the US. So you want to have the best relationship possible. And also, the arbitration community is a very small community, and you want to have and build good relationships with everyone. So,
in terms of the conflicts, I mean, there's certainly potential, but I think they're less, that they happen infrequently. First of all, in the traditional funding concept, as Claudia was saying, the client retains the authority to settle or not the case. And, the lawyers or the funder might say, wow, that's a good deal, you should take it. And the client may not want to. But normally there's, if you have a sophisticated, most of these investors who have cases are reasonably sophisticated business people, or very sophisticated business people. And there's often not a real huge difference of opinion of when there's a settlement proposal on the table. And the other thing is in these sovereign cases, you almost never get one anyway. So it is often theoretical, but not real.
Any other questions?
Yes. Well, first of all, thank you for coming. I know many of you are not based in Washington, D.C. So I do have a question from the perspective of a prospective user of litigation finance. And that would be, up to what point or what are the main elements that would be negotiable if they say they would go to you asking for help? What are the elements that as a funder you're willing to negotiate, or what are non-negotiables? Jeff, you want to take a step?
Yeah, sure. I mean, it's relatively straightforward. We agreed to fund the legal fees and expenses as well as arbitration costs for a matter, assuming that the matter was brought to us at inception, from filing of the RFA to award. In exchange for doing that, we agreed to an economic entitlement. Typically for us, it's IB, investment backed, plus a multiple on that amount, plus a percentage of net proceeds. Now, those vary depending on the kind of case it is. In treaty cases, obviously, you're looking at a higher multiple and a bigger chunk of the net proceeds, and that just reflects the fact that they cost more and they take longer. On commercial arbitrations, you can have a lower multiple because the average ICC case is done in 2.5 years. LCIA case is 18 months. So you don't need the multiple to go up so high. In some cases, you may add an interest rate component if there's a concern about really long duration, and that could be an interest rate that's on just IB. It could be an interest rate that's on the entire entitlement. There's a number of ways to play with it. In terms of the deal document, the LFA, the litigation funding agreement, or the capital provision agreement, as we call them, those are contracts, and there's standard clauses. You can look and see some examples online that make clear who controls the case that we've been talking about now. It is the client, and it is in concert in that direction of counsel. We don't have the time nor the desire to. I mean, I worked as counsel for about a decade, and it was fun, but I'm not doing that anymore. So we are not counsel. That said, probably the thing that we spend the most amount of time on is the analytics on counsel. So when I present an opportunity, I'm giving my investment committee the win-loss ratio of the firm, the win-loss ratio of the team that's on the case, and then we dive into the cases they won, what percentage of damages they were able to secure, the cases they lost, why they lost. We will reach out to people that were involved in the case on the other side. We do a fair bit of diligence because we can't control the claim. We really need to know who's acting as counsel. So that's very important, I would say.
Thank you. Hello, my name is Iyad. I'm a New York lawyer from Tunisia, and I have two questions to the panel. I am curious whether you agree or disagree with perhaps the intuitive conclusion or idea that the presence of a funder behind a claim has a positive effect in the sense that it allows for a better quality of the dispute, in the sense that the claimant that perhaps does not have the ability at the start of the claim to perhaps have all the expertise, the witnesses, all the logistics perhaps, or even to provide for a good quality dispute. And on the other hand, whether it is intuitively true or not, that the presence of a funder could have an adverse effect in the form of a confirmation bias on the tribunal. And I think, Claudia, you alluded to that earlier, whether the presence of a funder behind a claim for one party could perhaps maybe confirm the tribunal and the idea that that party has the better odds and allow them to go in that direction, even though they might have been persuaded otherwise had the funder not been present. Thank you.
I think on the first point, I think it allows more sophisticated, appropriate counsel to handle cases that they're steeped in. I don't think we'd want, maybe I'm speaking out of turn, but I don't think we'd want Steve, litigating or arbitrating a licensing agreement or some IP dispute, right? And maybe if there's not a funder involved, he, for whatever reason, would take a case that's sort of out of his wheelhouse. So I think you get appropriate, sophisticated counsel who know the area of the law, who, are appropriate. And I think that's what we try and do when claimants come to us, and I suspect my colleagues up here do the same, when claimants come and they say, can you recommend counsel that goes with your funding? That's usually a terrific opportunity because funders have relationships with a lot of firms and will likely know who sort of the best or most appropriate person could be. On the second point on the confirmation bias, I think that's in part our hope, but I also think the diligence we do is not sort of arbitrary. We're again going to find the diligence counsel and the outside experts who know the issue, who know all the questions at play. And so, yeah, it may be confirmation bias in part, but I think it's also getting the answers right.
We are at time, but thank you everyone for your time today. We really appreciate it. Thanks again to Jose Antonio, to Steptoe, to Stephen, and to all the panelists.